I hope by now make sure that there is a glass of champagne in front of you. Two champagne.
They don't want it. They don't want it.
Well, they have a toast. You can't have it. All right. Welcome to 2019 American Inn of the Court meeting. Last year, if you remember, those of you who were here in November, I told you, look around and look at the people's faces. These are the people that you will see for the next 6 months on a monthly basis. I promise you that you will see them more than you see probably your brothers, your sisters, your cousins, definitely. I asked you to look around and make sure that understand that probably in the past 60 days, and I would promise in the past 60 days, or in next 60 days, you will not have nice dinner in an Italian restaurant, even with your spouses or your partner. The people who are around you and sitting face to you or next to you are your friends forever. I consider American Inn of Court and your gatherings here tonight as a new step in my life and a new step in everybody's life. I consider American Inn of Court and your gathering together not a CLE, not a gathering of learning how to do a RFO, but how to be a better lawyer by associating with better lawyers. And in my humble opinion, everybody can argue, but only few people can have a good judgment. And the day that people think about each and every single of you, they will not remember you as an attorney. They will remember you for the judgments that you made in your life, either as an attorney or as a judge. I have the pleasure of hosting tonight 16 judicial officers, 11 of them active bench, 6 retired. Last time I said that this is the Society of Judges, the judges who were, the judges now, and the judges in the future. Many of judges that they wanted to be tonight, they are not because of the family gathering or professional commitment. Judge Lewis sent a special greeting to our speakers and every single one of you, and he sent me an email that we are going to have 10 new judges and commissioners joining us in 2019. 1, 2, 3, 4, 3 commissioners and 7 judges. I mentioned the names. Judges, Judge Cohen, Judge Copps, Judge Gisa is here tonight. He gave us the honor of being here. Judge Gordon, I arranged them on an alphabetical order, not in any kind of order. Judge Gordon, Judge Spear for Central, and Judge Thomas for also Central. We had commissioners, new commissioners in Commissioner Chen in CCW, Commissioner Davis in CCW, and I believe Commissioner Santos in Whittier. Now about tonight. I was thinking that in 1850, when they started writing California Civil Code and it became Family Code, or in 1969, or in 1984, when the body of the family law was passed, what was family law? Family law was like a piece of ice, a block of ice. some ideas that the legislator passed and said, today this is the law. But nobody knows how this law will shape. Well, this ice going to melt or going to take a body? It's going to become, in the hand of rodents, become a statue sitting on the Mediterranean or whatever, just, thinking. It becomes what? Family code in the hands of you, judges and attorneys. It became a body that today we recognize it as family law. You are the sculptor of this body of the law that one day it was given to you. And you made it the law the way it is today. And when we look at the law really with the past 40 years, one of the names that took this axe and just cutting at this thing was Hani Amado. So, and I'm sure Claudia is here, many of you have just done appellate and just you've been participant in this shaping. So we are here tonight is celebrating shaping of California family law in the past 40 years. This is what tonight is about. How you made California law. And only Hani and Judge Silverman, they just, really, I asked them and they gave us the honor of symbolizing and expressing this perspective of family law. It's yours.
Thank you. Thank you very much.
Yeah. Abbas, I'm going to take this out. See if that's easier. Can you hear us with this?
Yeah.
Okay. First of all, Abbas, thank you for those beautiful remarks and the idea that we together have been molding a body of law, and that's really quite beautiful. There's others in the room. Claudia was mentioned. Claudia is also an appellate specialist. Dimitri Karagianidis, with whom I have a pleasure of working quite closely, does appellate work. And Nancy Brucker is here, and she does dependency appellate work. And Ira has had appellate cases, and others of you may have had cases as well. So we together, and you on the bench, who have worked hard to, with great integrity and great concern, have applied the law also to the difficult fact patterns that come before you. So we've been really partners in this wonderful journey of defining law.
Our goals tonight, or at least my personal goals, are a couple of things. First of all, it's a real privilege to be invited, and thank you, Abbas. To have a conversation here with somebody whose work I admire. Hani, and in the interest of full disclosure, Hani and I go back our ways before I went on the bench and became involved in family law. She and I both have had the privilege and the burden of being presidents of the same synagogue at various points in time.
Yes.
So we've known each other a long time.
Privilege.
A long time.
No, the
No.
walls would fall down. No, the Temple Isaiah. Yeah.
But what I hope we can accomplish, she and I intend this as a conversation, so we hope we can chat. But I personally, I'd like to do a couple of things. One, if you've read Hani's list of published decisions, and if you haven't, you should, and your mouth will drop at how many important cases she's been involved with. Well, the fact that she has means there's lots of good stories in there, and I hope we'll be able to dig out some of those. But secondly, and most importantly, from the perspective of both lawyers and the judges in the room, I think what we're interested in talking about is what are the things about these appellate cases and about appellate practice that should inform the way we look at the work we're doing every day. What seems to be most significant, what are sort of important concerns that we ought to have in judges in writing our decisions, practitioners in preparing cases, and then in terms of the development of the law, some observations of where it's going. So I want to start with some of the support cases. If you look
Sure.
on the list, Honey's have been involved in a number of really important support cases, particularly involving pretty wealthy people. It goes back to in re Marriage of Huebner back in
Oh, wow.
2001, where an extraordinary high earner tried to resist disclosing his earnings. In re Marriage of Williamson, which personally I think may be one of the most significant, in which a wealthy family member actually avoided having his family's income imputed to him. And then most recently, in re Marriage of Usher, in which a wealthy individual who experienced a significant decline in income nonetheless was not able to obtain a reduction in child and spousal support because of his wealth. So let me ask to begin
Sure.
sort of the obvious question. In dealing with the very wealthy client and in thinking about the reaction that the courts of appeals are going to have to the wealthy client,
Yes.
and obviously it may be different
Yes.
case by case.
Yeah.
What have you observed?
Yeah, that's actually a great question. The case of Williamson is a bit distinguishable because Williamson, he actually was not a great earner. That is, they lived so far beyond their means because they could borrow money from their parents. They could get money whenever they needed to. They lived in a gorgeous house. They were part of the Chandler family. He did have some inheritance. And every time they needed money, they went to the father. And the father ultimately said, I'm a little tired of this. And so did, by the way, so did Mr. Williamson. He felt that burden of living beyond his means. And he ultimately went back to work for the Santa Barbara News. And so his case was a really his case is the easier kind of case because it was easier to argue to the court that this was his real income, and the court did distinguish the income that came from the parents from alter income because it wasn't regular, and the parents had finally stopped giving him money. But now when wealthy people come, I do say, we need to look at all of your assets because in Usher, his earned income from work dropped dramatically. But the court said that's not that interesting to us. It's not the change of circumstances because he has huge assets that should generate income. So now I say to people, let's look at your whole portfolio and not just be perhaps blinded or simply looking too narrowly at your income.
Actually,
Earned income.
one of the questions I've had after reading Usher is whether the capacity to earn more from assets was as important in that case as just being rich and living rich. If you understand, if I'm making
absolutely.
clear the distinction.
In Usher, the expert for the husband imputed 1% return. And he never revealed what his real return was. But he said 1 is reasonable, it doesn't tie up my assets. The wife's return was 4.5 or 4%, and he said that's much too much, it's really risky. And the court said the Court of Appeals said the evidence doesn't reveal what his actual return was. 1% on its face is too little, and he could earn more. So that's actually an important point to pause on. And I was thinking about this also when I was looking at some of the cases again. I think what's important in a presentation of a case is to go forward with a reasonable argument. The arguments that are extreme, 1% return, is a bit extreme. And they're going to be, if they win on the trial court and there's money to go to appeal, they're risky on appeal. And I would think that it makes your job easier too, or maybe it makes it harder if people come with reasonable arguments rather than the extreme arguments.
I think that's right. I've always thought Huebner was that kind of a case, or am I overstating it, where it was an effort to push the law perhaps beyond judicial tolerance.
Yeah. I wish I remembered
is-
Huebner a little better. I remember we were trying to build on the cases of the high earner not having to disclose. And if I recall correctly, Huebner was one of the early cases that said you have to do the Disomaster
Yes,
calculation.
I mean that seemed to
Yeah.
be the court's concern.
Yeah.
Was without disclosing the numbers, the court couldn't accurately do a Disomaster and decide what's really reasonable. But the proposition that
Yeah.
someone could say, "I'm so rich I can pay any amount of child support, so you don't need to know how rich I actually am. Just tell me what I'm supposed to pay," struck me. Maybe it didn't
Yeah.
actually come out that way in the way it was tried or on the Court of Appeals, but that's sort of the tone it seemed to have.
I think that when we look at cases now in 2019,
Right.
where cases have evolved or issues have evolved, and we look at them at the beginning of the evolution, they look differently. In 2019, we are all so used to the Disomaster, and you have to do the Disomaster calculation. It makes sense that you can't go in and say, "I'm so rich that we don't have to do the Disomaster." But at the time, it seemed like a pretty reasonable position to take. Just tell me what the kid's needs are, let the mother determine what she needs and develop that part of the case, and I'll pay it. So it didn't seem unreasonable at the time.
You may have answered the question, but I want to go back just 1 second to Williamson.
Yep.
One of the things that at least as a trial judge, is that you often have to deal with this question of individual wealth versus family wealth. I often see the argument where there is family wealth of he's part of a very rich family. The money is always there, and yet in Williamson, the court was prepared to accept he didn't have it,
Yes.
So I gather it must have been tried, and the evidence must have been made fairly clear.
The critical thing in Williamson was the father, the senior, said, "I'm not paying any more money." The court said that all of those loans they were advances on inheritance, and therefore they're really gifts. But what struck the Court of Appeal was, by any name, once they're determined to be gifts, that's not the end of the story. You have to go further and say, is this a gift will include his income? And the court said no, because the parents said that we're not giving any more money. I think where we're going to see family money be a problem, a reoccurring problem, is in attorney's fees. Because
How's that?
Because when the wealthy parents step in to help pay for their divorcing child's attorney's fees, and the other side then says, "I want a piece of that." Well, there's not a parent on the planet that wants to pay the divorce fees for the other side, not anyone that I know. And I think we're going to see increasingly under the Smith case that came out of, I think, Riverside, where the trial courts will be empowered to look at that source of income. I think there's some distinguishing things about Smith, and part of that will be how much the parent pulls the strings on how the litigation should be. But I think that's a pot that may be reached because of the desire for parity.
I mean, this issue of you can't order the non-participant parent to contribute the money has made me consider, and I think I may have
Yeah.
even ordered in those contexts, an order that basically says if you get money from your parent, you have to share that money with the other spouse. Any
Yeah.
thoughts about that kind
You
of
know,
thing, or have you
yeah.
seen those kinds of orders being being appealed?
I've seen the order appealed. I've had a case, an unpublished case, and the Court of Appeals sent it back because the trial court had incorrectly included the parents' contributions for child support, but they said it was not an error to include that income for attorney's fees.
Oh, interesting.
Yeah. So, and it's unpublished.
Right.
It's problematic. So in that same unpublished opinion, by the way, for those of you that are litigating these issues, the court suggested that Alter should be re-examined and that Alter has some problems in defining income specifically under 4058 and felt that the safety valve is really 4057, that you could make adjustments. But it was a little footnote that they threw in, and they said they didn't ask us to change Alter, so we're not.
They didn't like the analogy to income, but they said it's okay
Yes.
to consider it for As an adjustment.
as an adjustment. Yeah. So if you're litigating that, it's something to think about. Currently, of course, alter is good law for the judges. You're bound to it.
Right.
But on appeal, of course, sister jurisdictions are not bound to one another. And so Second District, in any event, seemed to be inviting a reexamination.
All right, and
Say something? On the Alter and the Williams kind of issue, you might want to look at Anna M. versus Jeffrey E., which is a published Second District opinion that said if it's not a family member, the white knight who's coming in voluntarily giving money, tons and tons and tons and tons of money to this other family, you can't consider that.
stand up and so everybody can hear you.
The Anna M. versus Jeffrey E. case, which is mine, I will disclose that. The Court of Appeals said that the white knight who was funding just about everything for Anna M., who didn't have the ability to really earn much of anything, should not be considered for child support purposes. It wasn't even relevant to the issue didn't allow for attorney's fees, because this spigot is not a mother, this spigot is not a father. And this is a totally unrelated third party who's doing this out of the kindness of his heart. We're not going to include this as income. So, third party, not parents, might want to look at it.
Any other thoughts you want to give about support or observations about?
I think that we've probably
Then
covered it quite a bit.
Let me shift gears.
Sure.
If you've looked at Honey's cases, another area that she's been very instrumental in dealing with are international move-aways. And some of the most interesting and I wouldn't say fun because these are too stressful cases
Yes,
to be
they're
called fun.
interesting.
But interesting cases that she's been involved with are those. And particularly a couple involving the State of Israel.
Right.
In remarriage of, is it Abergil?
Abergil.
In 2003, and more recently, JM versus GH.
Right.
In both cases, the mother was allowed to relocate with the child.
Correct.
But in some respects, the cases are different in the circumstances of the mother, at least financially.
Yes, that's right.
But they also, Abergil in particular, raises the issue of raises the issue of violence in Israel that occurred during the Second Intifada, and at least as a trial judge, I hear that argument being made a lot about Mexico and areas of cartel violence in Mexico. Could you talk to us about Abergil a little
Sure.
bit and that problem?
The marriage of Abergil is the case that my children know I want on my tombstone. I have one of those big tombstones at Home of Peace, so there's a lot of room. I love the case. I really love the case. And it was a question of this mother returning to Israel during the Second Intifada, and there was claims of violence, although where she was not violent. There was no violence there. And we really, there was because of the procedural status of the case, there was a stay requested, and that gave me an opportunity to put in evidence that I otherwise cannot put in the Court of Appeal. And one of them was a declaration from the Minister of Interior, by a different name, but something like the Minister of Interior in Israel, who spoke about how they take care of their children during the violence and the palliative care that they give to the families. And that was impressive to our court. I was told by some colleagues in Israel that a justice, the brother of one of the justices on the Israeli Supreme Court, had done a whole survey of cases around the world of what they were doing during the Intifada of sending kids back to Israel. And so I picked up the phone and I called the justice in Australia. The brother was a justice in Australia on their Supreme Court, and asked him to send me on his letterhead the cases. And I submitted that to our court with an explanation of the different cases. And around the world, people were struggling with this. And in some cases, almost all the cases, were sending the children back. Some of them were saying, let's look at this again in 6 months. But only a couple of courts. And I don't want to mention the countries because I don't remember them exactly. It's one of two countries, and they're both fraught with difficulty, so I don't want to mention the cases.
As I recall, because the Court of Appeals said if we'd required a bond, she wouldn't have been able to put it up, and
That's right.
therefore she couldn't have exercised her jurisdiction, her parent
That's right. I
rights.
think one of them, it must have been then perhaps in Arbigill, where it was about a $10,000 bond. I actually don't remember the detail too well, but that point is well taken. If you have a client that can't afford to pay, argue that you can't post that bond. But there were other things that were done, and I think it was in Gall's matter, where the court said if she holds that child, then he could put the money into a trust and not pay her support.
Yes.
And so
Yeah,
there
yeah.
was some
There were-
some teeth to the order.
Another interesting element of JM versus GH, which would apply even in non-international move-away cases, was the step-sibling issue.
Yes.
In
Yeah.
which actually a step-sibling was sort of created during the litigation, if you
Yeah.
could explain that.
Yeah. With regard to the step sibling, which is not the same thing as a half sibling, he was actually created. The father marries his new girlfriend. Actually, he had been with Gall for about 10 years. Then he marries this new girlfriend who conveniently has a son. And then he argues you can't separate the boys. Now, when he first makes the argument, their relationship was about 5 minutes old. But by the time it starts going through litigation, then the boys have been together now for a number of months. And the younger boy, which was Gall's son, started to really have a great deal of affection for the older brother. But the court ultimately said that the step sibling was something to consider, but it was not controlling. It was not controlling.
It wasn't the same as
It
a
wasn't
sibling
the same.
relationship and the standards for that.
Exactly. There was no presumption that you had to keep those boys together.
There's been a more recent international case that you were involved with, and I think I don't know whether you want to talk about it with our judge here,
Yeah.
but
Yeah.
WM
Judge
versus
Epstein.
VA.
Yeah. Okay. Okay.
Judge
So, yeah. So one of the new stars that you have on the bench is Judge Epstein, and you know that Judge Epstein is the son of Justice Norm Epstein, and that apple fell very close to the tree. Justice Epstein is well respected, newly retired, and Judge Epstein. I sat in on a couple of the proceedings, and it was really a pleasure. WM versus VA.
Decided just a couple of months ago.
It was
actually.
decided 1 month ago. It's final today.
Okay.
Yeah, today is the last day, and it's final today. And I think the takeaway of that case was a question of jurisdiction, of whether we would decide the custody case of a child, or whether another country would decide, a Central European country would decide the jurisdiction, would have jurisdiction to decide the case. And I think the important takeaway from that case is the other country was Belarus, and on paper they have excellent notice requirements, but they weren't implemented well. And I think the important thing that the Court of Appeals said was, you have to give notice in the foreign country as well for that foreign country to be able to exercise jurisdiction under the UCCJEA, to be in the running to say that they were the first to exercise, to have a custody hearing. So the takeaway for us as practitioners, for you as trial practitioners, is if you have someone in another country and you're trying to get the case here, when you speak with your co-counsel abroad, make sure that they're giving notice of their proceedings there that would meet the same requirements that would satisfy a California court. And then you would be in a position to say that state was first. So there's many good things in the opinion.
All right, let's shift gears again.
Okay.
I suspect that many of you were coming here expecting us to talk about Feldman. So out of fairness, we are. But before we get there, I want to talk about the subject of disclosure and fiduciary duty cases with some of the earlier cases that you dealt with. Let's start with in re marriage of Duffy. Do you remember Duffy? Duffy, in is a guy who invested, as I recall, a bunch of the family money in some rather imprudent investments that ultimately didn't pan out. And there were basically two issues in Duffy. One was the issue of whether he breached his fiduciary duty by not adequately disclosing, and then the second issue was whether he owed a duty of care such that the fact that he was imprudent in the way he invested and didn't act as a true fiduciary would was a violation. Yeah. What are your thoughts about that?
You know, my thoughts about the case as I look back at that case and as I reread it fresh after all these years is it's not a bad case. It's not a bad decision. At the time, we were really troubled because Patricia Duffy would ask for, you know, what are you investing in? And he would either not tell her or he would answer cursorily, which the trial court was not impressed with because it was too old. So if there's a practical question, make sure your evidence is really current. If you want to argue that someone doesn't give you information that you ask for, have more than one example. And so ultimately he said that she actually had a lot of information. And I think the difficulty of our field is there may be the right answers on paper, and this probably was the right ruling of the Court of Appeal, but it may not reflect the dynamics of a family. And we may never be able to reach the dynamics of a couple. So whether she had the right information or not about his investments, she had no power in that relationship to stop those investments. He was going to go off and invest however he was going to invest. But meanwhile, the court said that the law requires him to have given her information upon request, and he did that. He gave her information. And then he has these bunch of lousy investments. He makes a lot of money in some stock, and then he starts to dissipate it. He took that money and lost it. Well, he didn't exactly lose it. He starts, I think, with 200 and he ends with 200. In some ways, he has $200,000. It goes up to 600. That's when he should have sold, but he holds it. He's encouraged to liquidate everything and invest in this IT stock. He does, and then his whole portfolio goes back down to 200. And there, too, the court says he had no duty of prudent care. And in some ways, that's a good ruling, because otherwise you would end up having to decide, and we would end up litigating, was somebody prudent enough? Were they a guarantor of investments? And you don't want to hear those cases, and we don't want to litigate them. It's just too difficult to decide, was it a good choice at the time? After all, he made at one point $600,000. Should he have sold? So I actually think Duffy ended up, as I look back at it, being the right decision.
Duffy, for those of you who've dealt with this area, had an interesting history afterwards. If you followed the area, it generated some very swift legislation. And in fact, the legislature changed the disclosure rules, and the current disclosure rule incorporates some of the corporation code requirements that require not just disclosure only upon request, but actually for significant financial transactions that you disclose in advance. So, but notably, at least most commentators suggest that the legislature did not change the portion of the Duffy ruling that that held that there was no duty of care in the investments were made. There's some. If you read what's the briefcase publication. Anyway, there's some who argue that it might have made a change, but others who say that in fact it did not, and certainly the way the legislature did it. But anyway, if you have a Duffy problem right now, you're going to want to look and see that there was immediate legislative changes made after Duffy, and it's pretty clear now that disclosure of at least significant investments or significant financial transactions has to be made without a prior request. But at least it appears that this notion that you have to be prudent about it is still not the law. So now let's turn to Feldman. The question about Feldman is, can you run a business? And not send a letter every day saying, this is what I did today at the business.
You know, I think that's the really good question. And he actually had Aaron had somebody dedicated in his business of trying to respond to all of these requests, which came fast and furious. And then the other side was in a position to say they don't comply. But she was sending like a request a month. I think Feldman is troublesome because of that. I also think Feldman, one of the things that's always concerned me about Feldman is I think we need to do a better job of explaining business to judges. Judges, you guys have so many things that come in front of you, and we cannot expect the judges to know everything about all things. Our task as attorneys is also to be educators. And I think part of the problem in Feldman was the court did not understand the construct of his business. I was always bothered by the question with that house. The house was owned by Sunroad. He rented the house. It's owned by Sunroad. Everything that's in this big corporation that owns everything. He has a big corporation, and every single thing he does, he opens up a separate LLC. Now, he claims the bank told him to do that so that all of these transactions would be separate. And I think the trial court never fully understood that. And even as I reread Feldman, even the Court of Appeals sounds angry. And I never quite really understood that and why such a hefty sanction. He did disclose things, and he would even disclose things within a few months. And the other side was able to, Mrs. Feldman was able to continue to say, well, he didn't tell us right away. He formed this LLC in December, and he knew it was being formed, and he didn't tell us. There was one that I sort of also felt badly for Aaron. He takes out $1 million loan to buy an Israeli bond. And that structure is not surprising. He takes out the loan, buys the bond. When the bond pays off, he intends to sell the loan, pay off the loan. And so in his mind, it was never really an asset because it was never something he was going to hold. It was really an investment through Israeli bonds.
Did he use...
No.
He was buying it as a separate asset
He
after
bought it
they
as
were
an asset,
separate.
and he took out a loan to get it. He
A
didn't
personal,
Right.
He was the obligor. The community wasn't the
That's
obligor.
correct. That's
but the
correct.
court cited that as an example of a failure to disclose transactions.
Exactly, and it was $1 million transaction. Now, you know, for me, if it's $1 million transaction, that's a lot of money, and my kids will be really interested what I do with it. But for these guys, and in fact, many of these cases, the Usher case, we had the same thing. For these guys, $1 million could actually slip their mind, and so the court was pretty upset about that.
Yeah, I don't remember which case, but Feldman, if you'll recall, was a very large sanction as
$250,000.
And based on a collection of alleged failures to disclose, including buying a house through the business,
Right.
and opening a bunch of LLCs, which the business operated through, and this borrowing, a whole collection of, for those of us who don't live at that lifestyle, what looked very
Yes.
clear on the surface, and things that eventually came out, albeit 6 months, maybe a year in some cases.
They do come out. They come out during discovery when the deposition of his assistant is taken. So it's really a guy who's sort of saying, like so many of your clients may be, especially in these stratospheric earners, let me alone and let me run my building, my business, and Fred's going to take care of all the disclosures. And they would every quarter or so create a new printout of the company structure. They would rewrite which were the new companies, and they weren't as forthcoming as soon as they were created. They sent them over to the other side, but they came out within a couple of months, and there was no injury to the wife. Though the court made short shrift of that argument and said there doesn't have to be injury under the statutes. Now, interestingly enough, that was San Diego. In our district, I had a case unpublished, and I'm very sorry that it was unpublished and that I didn't think to ask to have it published, where there was a European collar. A European collar is when you take stock and you collar it so that anything above a certain amount the bank keeps, but the bank creates the brokerage house creates a floor, or the brokerage house keeps, and it creates a floor. So if stock goes down into the basement, you're okay because you have a floor.
I see.
That's a European collar. And the judge said that because he had not asked his wife to collar this extremely volatile stock, he had breached the fiduciary duty and sanctioned him. And it was close to a $2 million sanction because the court charged him with its highest value. And he had not asked his wife, after she kept saying no to other volatile stock they had, that they kept losing. And so he finally says, I'm not going to ask you. You don't know anything about stock, and you just keep saying no. I'm just going to protect it. And he did protect that stock, and the court still sanctioned him, the trial court. And the Court of Appeal reversed and said, and in fact, when I got up to argue, it was one of the best arguments I ever had, because I got up to argue, and Justice Miriam Vogel said to me, Mrs. Amato, we got it. And I got to sit down, and she said, "There's no harm. He protected the assets. No harm and no foul."
Yeah, I don't remember the case, so
but
the
that's
best I can do
unpublished.
for you is there are some published cases out there in which a court of appeals has said, since there was no harm from the failure to disclose,
Right.
we're not gonna sanction because of it. But Feldman.
Yeah, they were mad.
Feldman seems somewhat inconsistent with
Yeah.
that, because it's not clear to me whether she was financially harmed by any of what he'd done.
She was not financially harmed, and I think that the better cases are if there's no harm, no foul, because it also needs to reduce the tension in these cases. So, and those sanctions, boy, once you're slapped with a sanction, you're slapped with a $250,000 sanction and $150,000 in attorney's fees. Once you're slapped with that kind of sanction, he didn't want to give her the time of day. And he didn't want them to agree that today is Monday.
That's interesting.
Sure, he's mad.
Another one of the fiduciary duty cases that are, or at least just duty cases that you have been involved with was in re Marriage of Balkoff back in 2006, which involves what at least I, as a settlement judge, see on a regular basis, and that's a transmutation of a piece of property between two spouses, or a deed between two spouses, and an argument over whether the transmutation was done with undue influence. And in Balkoff, it was a husband claiming to have been abused by his wife, which caused him to
Yes.
do a deed to
Yeah.
the wife. Could you?
Yeah.
And the facts that relate to ultimately the trial court
Yeah.
and the Court of Appeals find that it was coerced. But
Yeah. Sometimes we have the good fortune of having a case that we care about, and the client is really likable, and the result is right. She threatened if he didn't transfer that property to her, and they were at a hotel in a hotel room about to go to an event, if I recall correctly. If she didn't transfer that property to him, she would withhold the children, and that's Balkoff.
Yeah.
He didn't realize that she couldn't really do that. And so he was quite frightened at the idea of not having the children. She was also, if I recall correctly, she was also physically abusive. But it was mostly this threat that she would yell and scream at him and threaten to take those children. And he deeded the house to her. And he may have even given her a piece of the business, if I recall correctly. I'm not sure that I remember that piece. But the trial court set it aside, and they were affirmed on. The court was affirmed on appeal that was undue influence. So that threat of the children.
Balkoff also raises another area that as a trial judge, again, I'm very interested in. That's statements of decision. And when the failure to do one, which I think was the case in Balkoff, or the failure to do one correctly, is cause for reversing a case or is a problem. Talk to us about
Sure.
statements of decision.
I love statements of decision. I never understood statements of decision, so I started to study them, and I really like statements of decision. The law, thankfully, has changed. recent opinion out of the Supreme Court, MF versus Monnier, I think, or MP versus Monnier, has said that it is no longer a reversible error to not issue a statement of decision when requested. And I think that's a very important case, because otherwise it could be a trap for the unwary of either the people who think they're going to abandon it, or the person who asks for it doesn't shepherd it, and then you don't have a statement of decision. But I'm happy to talk about statements of decision. One of the things that I think would be very helpful if all the nomenclature was the same, and I think it's important to, in terms of the correct nomenclature, it's in the Rule 3.1590 is the controlling court rule. And there's a difference between tentative decisions and proposed statements of decision. The confusion comes in when the courts call them proposed, tentative, proposed, or tentative possible opinions. It's just different names, and then they're supposed to operate as statements of decision, and that becomes really confusing. The others, and I would love to see the nomenclature the same. I think it will be helpful. The other confusing thing to litigants and certainly to appellate attorneys is at the end of a statement of decision when the court says it's so ordered and sign it. Because a statement of decision is not an order. So when you say it's so ordered, it becomes confusing as to, well, now what? Do we have to have an order? Worse yet, have you started the appellate clock? And I would argue you have not, because a statement of decision is not an order, and there is case law that says parties don't have to guess when that clock begins. So I think that's important. I also think it's a couple of things are important in terms of timing that the parties and the attorney and the judge may also have between them. If you want to set your own briefing schedule, which is fine, be sure that you give the full 15 days for objections, because objections are considered so important that if those 15 days are shortened without the party agreeing, that can be a reversal. It can be that they've been deprived of the full time. So I think that's very important to do. And also, the rules don't require a reply to the objections. And I would imagine you guys are delighted about that, because not a word is said that we don't want to respond to. But the rules don't call for a reply. So if you're going to allow replies, as I know are a habit of people wanting to reply to objections, then either order that replies will be allowed or state that there's no need for replies. And the truth of the matter is that as much as we would like to perhaps reply to objections, you've heard it. You've seen it. If there's been the tentative and then you get objections, you know what is in your decision and what's not. So the reply may be superfluous, satisfying to a client, but superfluous.
Back to your point about nomenclature and Rule
1590.
Yeah, if you look in subsection C, and I'm sort of speaking to my colleagues as much as anybody else, but to the lawyers themselves, it tells the judge what to do to clarify this situation. Either you're going to announce that this is just a tentative ruling, in which case there's no statement of decision yet, and you have to have a process for getting there, or you can announce this is my tentative ruling and my statement of decision, and therefore that's going to trigger the time period for objections, which is what my own personal practice, if you've gotten one of my tentative rulings, is I open up with a standard paragraph that says this is my ruling and this is my statement of decisions, and unless you object timely, and I refer them to the timely to the statute, it'll become my final statement of decision, and we're done. But the statute tells you what your options as a judge are, and therefore what you as lawyers can tell the judge and remind the judge to do to make it happen.
Also, it's a good point about reminding judges. I believe that judges want to do the right thing. I think that certainly here in our district, the judges are hardworking and are looking to do the right thing. And so I think you help the judge if together you and opposing counsel say, Your Honor, we were entitled to 15 days, or we don't really know what this, you're calling it some name that sounds right to your ear, but it's not right. And we're entitled to, or whatever, our time for objections. Or, as I'm seeing some judges do, they're entering the order before the statement of decision process is completed. And it's premature. You should not be doing that. And you and co-counsel can say to the clerk, please alert the court to these concerns that we have and correct it. I also think we had talked about this when we were talking about the program with regard to statements of decision. If you're invited to write the statement of decision and the judge has given you a great order, but some of the reasoning was a little flimsy, I think that it is perfectly appropriate to, in the statement of decision, if you're asked to prepare it, for you to, I use the word rehabilitate, but help out the court. So I remember years ago there was a relatively new judge who had decided a custody matter. And he had decided the custody matter in the favor of my client. I was part of the team. And it was like on some new wave thinking. And the words best, the words interest did not appear at all, let alone together. They didn't appear at all in the court's recitation of its decision. And so when we were asked to do the statement of decision and we got the transcript, we put down the court's reasoning and we added all the good reasons that the facts added up to the best interests of the children for the custody order to be what the custody order was. Trial counsel was a little nervous because the court had not articulated those words. But the court, in fact, signed that statement of decision because we were helping the court. And the court looked at it. There was nothing in there. We didn't make up facts. We didn't say today was Tuesday, when in fact the court had ruled it was Monday. And so we were really helping the court and insulating that case from appellate reversal.
Yeah, my own personal experience, and this is one of these questions of pet peeves, is too often when I have asked for statements of decision to be prepared, the winning side or the goes overboard, and they throw too much in there that's either unnecessary or goes way beyond anything that I've articulated on the record, and so I end up having to edit a lot of that out, and I'm uncomfortable with it. I certainly don't quarrel with the point you've made where you think you've got something that the judge meant to say but overlooked. But be cautious, I think, about trying to stuff too much in there that the judge didn't say. One other bugaboo, and it may be more personal than anybody else. Some of us are more articulate than others when we recite our decisions on the record. And the statement of decision that comes back with our statements as spoken, ours meaning the judge's statements as spoken on the record, which may have seemed completely sensible and rational when spoken, but when they come back as incomplete sentences, I would urge you, clean up the judge's grammar.
Yeah.
The judge will appreciate that. I'm not inclined to cite a statement of decision that highlights my inarticulateness, frankly. But
while we're talking about statements of decision and you talk about these action-packed statements that include every single thing under the sun, we might pause at the request for statement of decisions or the requests or the objections that you didn't list, how we got to Monday and every single calendar that you looked at to know today is Monday. The request for statement of decision does not ask the court, the word out of one of the cases that I love, which is People versus Casablanca Convalescent Home. The request for a statement of decision should not be an inquisition. The statement of decision is supposed to be what are the principal facts that the court has relied on to come up with its decision. And the court can address those principal facts. The court does not have to say why Harvard Westlake is better than some other fabulous school here on the West Side or in the Valley or anywhere. The court does not have to go to every single evidentiary fact. And I would urge you guys to curb your statements, to really focus on what are the principal controverted facts, because that makes you think through the case. And that makes you think through what do I have to have decided to win the case, and do I have merit here for an appeal? And when you guys get these long inquisition kind of questions, I would suggest that you sort of in your mind corral them into the major issues and just answer the major issues and answer them in a narrative.
Yeah, the trial judges are very familiar with the case law sentences, like Honey has cited, that tell us we don't have to answer all of the argumentative questions that often, the 156 argumentative questions.
With subparts.
With subparts that are often put into demands for statement of decisions. And I understand the point. You're trying to force us to think about your arguments. The problem I think from a litigation standpoint is I think that approach causes you to get shorter shrift than you might otherwise get, because they either tend to be one-sided in the way the questions are. They're when did you stop beating your wife type questions, or when did you as the judge stop being irrational in your decision making. Some of them come close to that, close to that, and then ultimately what you end up with is the judge saying, and most judges will find the cases that say it doesn't have to be an inquisition, is simply a citation that says these are improper questions, and therefore the judge is not inclined to answer them.
And the statement of decision is also a place to put in your bad facts. If you've won and you had bad facts and you had won anyway, put into the statement of decision that the court weighed that your client is whatever, and notwithstanding those problems, the court has weighed it still in your favor. Because no case is pure. No case is going to have 100% good guy and 100% bad guy.
We have about like 5 minutes if...
Oh, okay.
I think one case I would like to talk about, let me find my notes, SM versus EP, the one, the domestic violence case.
Yeah.
And the reason I want to talk about it is it's a rare decision where a court of appeals reversed the grant of a restraining order. If you're looking for a case that does that, there aren't many published cases. In fact, I'm not sure if there's another one out there, but this 2010 case.
Yeah.
Talk to us about how that happened.
Sure. SM versus EP, there was no violence. I think he may have said something like, if you take our baby away from me, I could kill you, or something like that.
But the trial judge found, the
That
trial
there was-
judge said there was no threat that was
That's right.
made.
The trial court said there absolutely was no threat. And
Because there was a he said, she said.
it was he said, she said. Actually, his sister was on the phone. He called her sister to say she just called the police on me, and the sister was on the phone the whole time during
Yes.
the arrest. And then he was so agitated, and he threw his watch down, and the police then said, well, we're taking you in now. And he said, if you take me in and you let her walk out that door with that baby, she's going to leave the state, and I'm never going to see that baby again. And she did leave the state. But what really interested the Court of Appeal was the impact of a restraining order. They understood that the trial court ultimately says, I don't think there was really domestic violence, but I see how upset you get in court, and I think I have to separate you guys. Well, she's in another state. I don't know how much more separated you have to be between you live here and she lives there. But the Court of Appeal was bothered by the impact, I think it's 3044, 3444? 3044. Where you have a presumption against custody to the parent who's accused of domestic violence. And the Court of Appeal saw this as simply her mechanism to really both call the police and get him off of her back so she could leave with that baby, and then preclude him from getting custody.
Notably, I think that the trial judge may in fact have done something wrong under 3044, because the trial judge basically said, well, I'm granting the restraining order, but I don't think this is a 3044 case.
That's right.
Without making the proper findings to get him there. But the Court of Appeals relied upon that as evidence that the trial judge just didn't really think there was domestic violence.
The Court of Appeal relied upon that, but also the Court of Appeal was troubled by the impact. And they hadn't realized really until that case what I call the tail, the TAIL, of these domestic violence findings. So that really concerned the Court of Appeal. Yeah,
And
that was really a
Succinctly, this case stands for the proposition that badgering is not domestic violence. So if you can get the trial judge to characterize the behavior as badgering rather than harassment, you have a shot at winning.
Yeah, yeah. And also, I think you can argue that, and I did in that case, that sometimes we say things in the heat of anger. And if we're looking for people to never say something in anger, we're going to, or if every word you say in anger is the grounds for a restraining order, you're going to open the floodgates. So, do I have 2 minutes to say a couple of things that I recommend?
Go to it.
Okay. One of the things that I recommend in your title of pleadings, respondent's supplemental response to petitioner's second supplemental response to the petitioner's RFO, period. Try to come up with something that is descriptive of who the party is filing, maybe put in lowercase some of that interior language, and then tell us what RFO it is. Because when I pick up the record, and I've had a bunch of RFOs, and I'm trying to put together the appellate record, it's really confusing, and then would be confusing to the Court of Appeal.
And I want to reinforce that because given that we're now dealing with digitized dockets, it's the express title that shows up in our digitized docket. And sometimes
That's
if
right.
they're insufficiently descriptive, they're hard to find. And particularly with your opposition and reply briefs, you know, cross-reference the RFO filing date or
Early
something.
on, exactly. The other thing that I am always talking about is initials are a false economy. If it's not B of A, or I don't like to say UCLA, I can say UCLA, we're in Westwood, or UCLA, don't use it. Because you're living with your case, so you know that some long string of initials stands for your client's company. But nobody else really knows that. And it's so crazy-making to read a brief or to read the record, and you have to stop every once in a while to say, well, who is this company? Or who is that they're referencing. So I think that initials are a false economy, and remember that your ultimate reader is the bench. They've got a lot of cases, or the Court of Appeal, and they're not going to remember all of your abbreviations. The other thing that I really don't like, except in literature and poetry, is adverbs and adjectives. If the other side is a bad actor, tell the court what they do. The court's going to figure it out. You don't have to take up space with a long line of adjectives or adverbs, assuming that the court won't get it unless you call him a really no good, dirty, rotten scoundrel. He's going to get it. The courts are going to get it. And it just is degrading. And the courts of appeal hate it. I would assume you guys do too.
Yeah, domestic violence cases, particularly where we've got the declaration that repeatedly says, I was harassed in October, and I was harassed in July, and I've been harassed for 25 years, but never actually tells me what the person did that they're labeling harassment. It just doesn't work.
The other things are, I'm going to skip a couple, but please explain your terms when your accountant is testifying and when your psychologists are testifying, because people don't necessarily know what an S corporation is or how it impacts or other perhaps tax kinds of language. Therapists, to read a record of a therapist is notoriously opaque. Whatever is a emotional attunement, there's probably English for that, but it's hard to know. And there's the other one I think is the new expression is the attachment bond, the attachment relative. Have them explain what these mean so that when the Court of Appeal picks it up, the Court of Appeal has a reference, and when you guys too have a reference. And as I mentioned under Feldman, or if I didn't, I want to underscore it. If I did, I want to underscore it. If I didn't, then let me mention it again. Educate the court carefully about the business. If you have to bring in charts, if you have to, whatever you need to do to really educate the court of the way a business is run, because every business is going to be run differently and uniquely, and you want the court to be able to understand that, both the trial court and the Court of Appeal. This is something we had talked about that we should mention. Abbas, in our discussion a couple of weeks ago, had asked, what's the human intangible in a courtroom? And I had said, I think it's credibility. I think you need to walk into that courtroom with credibility on either the way that the facts are presented to you or the legal arguments. If the case law says what it says, try not to draw out the one line that's in your favor. And as Justice Gilbert would say, pretend that you see a smile without the cat from Alice in Wonderland. Be truthful in what you understand the law to be. You might be wrong, but in good faith, you might understand the law to be that. Don't distort the law, and don't hide facts. Really go into that courtroom with credibility. I often describe to my clients that the third partner in our relationship is the law. And I think that's important when you practice in front of the trial court as well.
Absolutely. There's nothing more, to me, there's nothing more persuasive than either the witness or the lawyer who stands up there and says, I know, I'm going to concede to you, they won't say it this way, but who concedes the bad fact, who makes an admission that isn't helpful to them, and then says, notwithstanding that, which is the point you made earlier. That automatically tells me you're credible with me. You're being honest. That's a very persuasive technique. On the other hand, the lawyer who pretends it doesn't happen, or the client who diminishes it or lies about it, raises the specter of the one lie will destroy all of your testimony.
Absolutely. You know, when I have a finding, when there's a finding that the client is not credible, I tell the client that they should not bother appealing, and I won't take the case, because I have not won a single case. In fact, I've argued to the Court of Appeal they weren't credible on this area, but the law's with them, and the Court of Appeal is not interested. I've not won one of those cases. I tell the clients all the time, don't lie about junk, because that will tarnish the whole case. Don't lie about junk, and don't lie about the good stuff. Don't lie, because it tarnishes the whole case. And generally, the lie is about junk.
Yes, often it isn't the key issue. But the other side is so busy trying to beat you over the head with that bad fact that the client gets defensive or thinks they have to avoid it when it doesn't go to the heart of the issue.
Yeah.
Well,
Boss, have we probably done...
you did a great job, and to the extent that there is a glass of champagne in front of you, and if you don't have a champagne, I would like to propose a toast to our speakers and to all of you, and wish all of you a very happy New Year.
Happy New Year.
Happy New Year. Say, okay, right, quiet. No, that's not part of the program. No, Honor, this is not true. Tonight we couldn't be together in this rainy evening. Many judicial officers, they drove miles in order to be here after a busy day. I would like to take a few minutes to mention the name of the judicial officer present tonight and thank them for coming. I'll start with Honorable Boxer. With the Honorable Byrd, Judge Byrd. Maybe we can save our applause to the end. Commissioner Clements, Honorable Clements. Judge Doherty, Judge Epstein, Judge Gieser. Maybe you raise your hand, the new one, so we all know you. Judge Getz, not here tonight. Judge Goldberg. Judge Riff. Judge Rosen. Judge Short. Judge Silverman. And Judge Luna from Long Beach. We had 5 judicial officers, which they sent me email, and they to all of you, and apologize for one reason that why they couldn't really drive tonight. Tonight also could not be put together without sincere and continuous effort of the executive committee of the American of the court. I would like the member of the executive committee to stand up so people can see you. Where are you? Please. I thank you very much. We have the fingerprinting going on for another hour or so. So we're going to have coffee, we're going to have dessert, sit down here, commingle, do networking, and until next.
You want to pitch?
Yes, yes. Now, I wanted this to be a surprise, but Judge Silverman didn't allow me. Next Monday, next month, second Monday of February, one of famous faces of family law will be here before us. Garrett Daly, we're going to fly from Northern California, probably in his own airplane, and will come here to share 1 hour with you. It's going to cost him about the whole day, but he is very excited to be here, and I invite all of you that please, if you want to come, please send me an email, judicial officers, especially if I don't have your emails. Please respond to RSVP that we send you through our national system. This month I had to go through my personal email and send it to you to make sure that you get but please respond to us. And on that note, thank you again, and again, Happy New Year.